Hi, this is Fred Niemann of Hanlon Niemann, a central New Jersey law firm practicing franchise law in all 21 counties of the state of New Jersey. This video today is directed to you franchisees, the holders of a franchised business in the state of New Jersey. You paid a lot of money for your franchise. You reviewed a document that was probably 4 inches thick with lots of exhibits and tabs. A lot of promises were made to you by the franchisor, particularly if it was an early or startup franchise, and now you're starting to run into problems. Either failed promises, material misrepresentations, inadequate sales, or a failure of the franchisor to perform the kind of support and backup they promised you when you signed your document. Then you get a notice from the franchisor saying they're terminating your franchise agreement. Well, not so quick. New Jersey is, generally speaking, a pretty weak franchise protection state, but the state has adopted the Franchise Protection Act and requires that for a franchisor to terminate your franchise in this state, he or she must establish good cause. Well, what's good cause? Good cause is a material breach of your agreement with the franchisor which seriously compromises their ability to successfully operate the franchise in New Jersey. Before they can terminate the franchise, they have to give you notice in writing. They have to state with particularity what it is that you're alleged to have failed to do under the agreement. And that failure has to be, again, a material breach, something very important within the franchise agreement. Certain provisions of the agreement require notice and an opportunity to cure. Other violations are not so generous and allow the franchisor to terminate the agreement almost immediately. But don't lose hope. If your agreement is such that you believe that defenses exist, New Jersey does allow you to assert all of your common law defenses against the franchisor as part of your good cause defense against an arbitrary refusal to continue the franchise relationship. And again, in the franchise notice, the only way you can be terminated is based on the alleged grounds of the violation. So if you're a franchisor or a franchisee in New Jersey and you are now in the midst of a contested franchise agreement, I want you to give us a call. Let us take a look at it. We'll give you independent advice and direction. We think we understand New Jersey's practices pretty well, both in the state and federal court, and we look forward to working with you and helping you out real soon.